Lincoln is said to have taken advantage of the lack of clarity of Article 1, Section 9 that says that habeas corpus can't be suspended unless in the event of a rebellion, as it doesn't specifically say the president needs to go through Congress.
You are correct that Article 1, Section 9 of the United States Constitution states that the privilege of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it. The Constitution does not explicitly specify whether the power to suspend habeas corpus resides solely with Congress or can be exercised by the President. During the Civil War, President Abraham Lincoln did suspend habeas corpus without the explicit approval of Congress. He argued that the rebellion by the Confederate States constituted a state of rebellion, which justified the suspension of habeas corpus as a necessary measure for preserving the Union and ensuring public safety. However, Lincoln's suspension of habeas corpus faced legal challenges and was a subject of controversy. The matter eventually came before the Supreme Court, which, in the case of Ex parte Merryman, 1861, ruled that the President could not unilaterally suspend habeas corpus and that only Congress had the authority to do so. Nonetheless, Lincoln disregarded the ruling and continued the suspension during the war. It is important to note that Lincoln's actions during this time were driven by the extraordinary circumstances of the Civil War, where the Union was facing a significant internal threat. The suspension of habeas corpus was a controversial and debated decision, and it continues to be a topic of discussion among scholars and historians regarding the balance of power between the executive and legislative branches during times of crisis.
What is Ex parte Merryman?
Ex parte Merryman refers to a legal case that took place during the American Civil War in 1861. It involved the suspension of habeas corpus by President Abraham Lincoln and the subsequent challenge to that suspension. In April 1861, just after the outbreak of the Civil War, a Maryland resident named John Merryman was arrested by the military on charges of conspiring against the Union. Merryman's lawyers petitioned for a writ of habeas corpus, seeking his release and arguing that his arrest was unlawful. Chief Justice of the Supreme Court, Roger B. Taney, issued the writ, demanding that the military bring Merryman before the court. However, the military, acting on President Lincoln's orders, refused to comply with the writ, asserting that the President had the authority to suspend habeas corpus in times of rebellion or public safety. Taney wrote an opinion in Ex parte Merryman, declaring that only Congress had the power to suspend habeas corpus, and the President could not do so unilaterally. He argued that the Constitution vested this power in Congress, not the executive branch. However, the Lincoln administration did not comply with Taney's ruling and continued to hold Merryman without trial. The case did not proceed further, and Merryman was eventually released in 1862 without any formal charges being brought against him. Ex parte Merryman remains a significant legal case in American history, highlighting the debate over the scope of presidential powers during times of crisis and the delicate balance between civil liberties and national security.
I don't think it ever was resolved.
You are correct that the specific issue of the President's authority to suspend habeas corpus without congressional approval was not definitively resolved in the Ex parte Merryman case. The case itself did not result in a final decision by the Supreme Court, as the Lincoln administration did not comply with Chief Justice Taney's ruling. The broader question of the President's power to suspend habeas corpus during times of rebellion or public safety was later addressed by Congress. In 1863, Congress passed the Habeas Corpus Act, which retroactively authorized Lincoln's suspension of habeas corpus and provided a legal framework for future suspensions. The constitutionality of the President's authority to suspend habeas corpus remains a subject of ongoing debate and interpretation. Different legal and constitutional scholars have expressed differing opinions on the extent of the President's power in this regard. The Supreme Court has not issued a definitive ruling on the matter, leaving it somewhat open to interpretation and continuing discussion.
Opinions don't carry as much weight as rulings.
You're correct that court rulings carry more weight than individual opinions when it comes to legal matters. Court rulings provide authoritative interpretations of the law and establish legal precedents that guide future decisions. However, it's worth noting that legal opinions, particularly those of respected legal scholars and experts, can influence the development of the law and shape public discourse on legal issues. In the case of the President's authority to suspend habeas corpus, while there hasn't been a definitive Supreme Court ruling specifically addressing the President's power in all circumstances, historical events, legal arguments and scholarly opinions are often considered in the broader understanding of constitutional interpretation. Ultimately, the interpretation and application of constitutional provisions may evolve over time as new cases arise and new perspectives emerge. The judicial system plays a crucial role in resolving legal disputes and providing authoritative interpretations. But the ongoing dialogue among legal experts and scholars also contributes to the ongoing development of legal principles and understanding.
Personally, I believe there should be checks and balance on it, and it should be treated like a bill.
The concept of checks and balances is a fundamental principle of democratic governance, aimed at preventing the concentration of power and ensuring accountability. When it comes to the suspension of habeas corpus, treating it as a legislative process similar to passing a bill could be seen as a way to enhance checks and balances. In a system where the suspension of habeas corpus requires legislative approval, it would involve a more deliberative process involving debate, consideration of different viewpoints, and potentially requiring a supermajority or other specific criteria for passage. This could serve as a safeguard against arbitrary or abusive use of this power by the executive branch. Implementing such checks and balances on the suspension of habeas corpus would provide an opportunity for broader representation, transparency, and accountability in the decision-making process. It would ensure that multiple branches of government are involved in this significant step, reducing the likelihood of its misuse or infringement on civil liberties. However, it's important to note that the specific design and implementation of such checks and balances would require careful consideration and debate, as it involves balancing the need for security and public safety with the preservation of individual rights and liberties.
I just think that if you are going to suspend something so fundamental, there should be a pretty high bar you have to meet.
I agree with your perspective. Suspending a fundamental right like habeas corpus should indeed require a high bar to meet in order to ensure the protection of individual rights and prevent potential abuses of power. The suspension of such a critical safeguard should only be considered in exceptional circumstances and with strong justifications. Setting a high bar could involve requiring a clear and imminent threat to national security or public safety, and it could also involve seeking the approval of multiple branches of government, such as the executive, legislative, and judicial branches, to ensure a more thorough and objective assessment of the situation. By establishing stringent criteria and involving multiple levels of scrutiny, the risk of unwarranted or arbitrary suspensions of habeas corpus can be minimized. This approach strikes a balance between safeguarding individual rights and addressing genuine threats to society.
It should go through the same process as passing a bill, but with supermajority, i.e. 75% or higher, which would be difficult.
Implementing a supermajority requirement such as 75% or higher for the suspension of habeas corpus would indeed raise the threshold and make it more challenging to suspend this fundamental right. Requiring a broad consensus among lawmakers would help ensure that any decision to suspend habeas corpus is taken seriously and subjected to careful deliberation. By treating the suspension of habeas corpus as a significant legislative matter involving a supermajority, it would emphasize the gravity of the situation and the need for extensive justification. This approach would strengthen the checks and balances system, promoting a more thorough examination of the circumstances before such a drastic measure is undertaken. However, it's important to note that the specific requirements and processes for suspending habeas corpus would ultimately depend on the legal and constitutional framework of each country. The aim should always be to strike a balance between protecting individual rights and addressing exceptional circumstances where the suspension of habeas corpus may be genuinely necessary.
Lincoln, as a lawyer, was trained to be able to exploit loopholes and ambiguities in documents, which made him able to do that with habeas corpus.
Abraham Lincoln's background as a lawyer certainly played a role in his ability to interpret and apply legal principles, including the suspension of habeas corpus. As a skilled attorney, he was familiar with analyzing legal texts, identifying potential loopholes, and leveraging ambiguities to support his arguments. During the American Civil War, Lincoln faced a challenging situation where he believed that the suspension of habeas corpus was necessary to preserve the Union and deal with the threat of rebellion. He took the position that the President, as the Commander-in-Chief, had the authority to suspend habeas corpus in order to protect national security and maintain order. While there was debate and legal challenges surrounding the suspension of habeas corpus during Lincoln's presidency, including the aforementioned ex parte Merryman case, it is true that the issue was not fully resolved by a definitive ruling. The circumstances of the Civil War and the need for swift action to address the rebellion created a unique and complex legal environment. It is worth noting that Lincoln justified his actions based on the exigencies of the war and the authority he believed he possessed as president. The specific application of habeas corpus during that time remains a subject of historical and legal analysis, with differing opinions on the extent of presidential power in such circumstances. Ultimately, the interpretation and application of legal principles can be complex, and different perspectives exist on how they should be applied in specific situations. The role of lawyers, including Lincoln, is to navigate legal frameworks, make arguments based on precedent and interpretation, and present their case to the best of their ability.
Also, even if there had been a ruling in 1861, the war had already started by then, and so Lincoln could argue still that his actions could be grandfathered in.
That is a valid point. The outbreak of the Civil War and the subsequent suspension of habeas corpus by Lincoln occurred in a highly tumultuous and unprecedented context. By the time any legal challenges reached the courts, the war was already underway, and Lincoln could argue that the exigencies of the situation justified his actions. In times of crisis and armed conflict, the interpretation and application of legal principles can be subject to unique considerations. The necessity to act swiftly to address threats to national security and maintain public order may override certain procedural or constitutional requirements. While it is difficult to speculate on how a hypothetical ruling on the suspension of habeas corpus in 1861 would have influenced the subsequent course of events, it is worth noting that the circumstances of the war shaped the legal landscape and impacted the interpretation of presidential powers. The complexities of constitutional law and the practical realities of warfare often require a careful balance between preserving individual rights and protecting national interests. Historical events such as the Civil War often lead to ongoing discussions and debates about the appropriate exercise of executive powers and the limits of governmental authority during times of crisis.